Thank you for joining us tonight, and welcome to the Northwest Consumer Law Center webinar series, How to Survive the Financial Effects of COVID-19. My name is Amanda Martin, and I'm the Executive Director of the Northwest Consumer Law Center. Today's webinar is Dealing with Debt Collectors During COVID-19. If you have questions during our presentation, please enter those in the chat box on your right. We will be answering questions at the end of the presentation. Attending this webinar does not create an attorney-client relationship. This presentation will provide legal information, and it is not a substitute for individualized legal advice. If you're seeking legal representation, you're welcome to contact the Northwest Consumer Law Center after this session. We'll be posting information on how to apply for our services at the end of this webinar. And with that, let's begin today's presentation. Today, we will be covering Washington's garnishment suspension of consumer debt. We'll be talking about how garnishment worked before COVID-19, and we'll be talking about what new protections are in place due to this public health crisis. We'll also be talking about your rights when dealing with debt collectors. We'll be doing a quick overview of the laws that protect you when you're dealing with debt collectors, and we'll be talking about the steps you can take to protect your rights. First, we're going to talk about how Washington has protected consumers from garnishment before COVID-19. Unfortunately, Washington earned a C grade from the National Consumer Law Center study, Still No Fresh Start report, for how they protected consumers from garnishment in 2019. A C grade meant protections have gaps and weaknesses. This means we have a lot of work to do in Washington State to protect consumers and their families from poverty caused by garnishment. Continuing with how garnishment worked before the garnishment suspension was in place, most garnishment starts with a lawsuit. A lawsuit typically begins with service of a summons and complaint. This generally involves somebody coming to your door and handing you or somebody that you live with legal paperwork called a summons and a complaint. From there, you typically have 20 days to send a response in. And that is a typical rule. There sometimes are longer or shorter reply periods. If you do not file a response during that time period, a debt collector or a creditor can obtain what's called a default judgment against you. This means that they receive a judgment because you did not respond. It's by default. If a judgment is entered, a creditor can then ask for a writ of garnishment to withhold wages. So this means take money out of your paycheck to send to the creditor or take your funds out of a bank account. But be careful, not all debts require a judgment before garnishment. Some debts, like student loans, may be offset from federal benefits without a judgment being entered. But there's some good news. Garnishment on consumer debts is suspended in Washington State until May 14th, 2020. The governor entered Proclamation 20-49. They recognize that Washington families are suffering financially during the COVID-19 crisis, and that continued garnishment during this time was affecting people's ability to buy basic necessities for themselves and for their family. The suspension was also meant to protect federal stimulus checks from garnishment, as those federal stimulus checks were meant to help families provide for those basic household needs during this time, not pay money back for creditors. So how does this apply for you? The first question is whether you have a consumer debt. A consumer debt is a debt incurred for personal, family, or household purposes. This includes medical debt, credit cards, and student loans. Some things that are not consumer debt are child support obligations, court fines, legal financial obligations, also known as LFOs, restitution from criminal cases, and most business debts. I say most business debts because some debts that people might consider business debts can fall into consumer debt. If you have a question about that, you should definitely speak with an attorney about what your debt is classified as. So how does this order affect you? Garnishment on consumer debt was suspended on April 14, 2020. That suspension went into place immediately. This means that creditors should not seek new writs of garnishment, that the court clerk should not issue writs of garnishment, and that if a bank or an employer was holding on to a consumer funds, those should be released immediately. It also provided for no interest on judgments for consumer debts should accrue during this period between April 14th, 2020 and May 14th, 2020. The order does expire on May 14th, 2020. We do not know whether the governor will extend this garnishment suspension past May 14th. We know that the garnishment suspension was intended to protect federal stimulus checks too, and we know that not everyone has received their federal stimulus check yet. So we're hopeful that if these checks have not been received yet, that it will be extended, but we do not know that. So continue to check for updates. Northwest Consumer Law Center will be continuing to post updates on our Facebook and our Twitter feeds about this issue. And we also recommend that people review their options now. We expect that as soon as this order expires, that creditors are going to go out and seek those writs of garnishment. So there's going to be an increased amount of garnishment once this order expires. So we recommend that people seek legal help now, so that way they know their options and they can avoid garnishment when this order expires on May 14th. What else should you know? Washington courts, most of them are operating in some capacity right now. You can go on the Washington court's website to see what particular court has what restrictions they have in place right now. Some are only processing emergency motions. A motion for default is typically not an emergency order. Other courts, like our federal bankruptcy court, are operating pretty much like normal, just without in-person hearings. They're holding those hearings telephonically. Most courts are not processing motions for default judgments during this time. That does not mean that you should not respond if you are served with legal paperwork during this time. We want to make sure that people are still meeting their deadlines. So if you are served with a lawsuit or you have an outstanding deadline, you should definitely seek legal advice as soon as possible. Other things that you should know: Washington's stay-at-home order is currently in place through May 4th of 2020. That date is coming up soon. The governor just announced that they will extend some parts of the stay-at-home order. We do not know which ones. But right now, we know that debt collectors are not included in the list of essential businesses. However, what is important for people to know is that law offices are still considered essential. And some lawyers and law offices operate as debt collectors. So some debt collection activity is taking place during this time. Under Washington's stay-at-home order, lawyers and law offices can continue their essential operations. So what are your rights? So we have the Fair Debt Collection Practices Act, which is federal law, and we have Washington's Collection Agency Act, which is state law. These are very similar laws. Washington's Collection Agency Act was intended to provide more broad protections than the federal law. Generally, these laws prohibit harassing, abusive, and unfair collection attempts by debt collectors. Debt collectors are third parties who collect on the debts of another. So if you have a credit card with Chase Bank and Chase Bank is calling you about it, Chase Bank is not a debt collector. But if Chase Bank then sends that debt to ABC collectors to collect on, and ABC collectors calls you, that's what a debt collector is. These laws are very broad. They apply to a wide variety of conduct, including collection letters, phone calls, and most litigation activity. Now let's go over some of the restrictions that the Fair Debt Collection Practices Act and Washington's Collection Agency Act put on debt collectors. Under the Fair Debt Collection Practices Act, debt collectors may not call you before 8 a.m. or after 9 p.m. unless you explicitly tell them that that's a convenient time to call you. They cannot call you at work if you're told that you're not allowed to get calls there. So if you receive a call from a debt collector at your place of employment, and you do not want them to call them there, you need to tell them that. They cannot contact third parties except to get your contact information. And even in that instance, they are very limited in what they can tell a third party. The purpose of this law is to keep your personal and private information confidential. So a debt collector cannot call up your mom and say, I'm trying to reach your son. He hasn't paid his bills. I'm a debt collector. What's his phone number? They're not allowed to do that. They're also not allowed to harass you. They cannot threaten you with violence or harm. They cannot use obscene or profane language, and they cannot repetitively call you for the purpose of annoying you. So if a debt collector is calling you 5 times in a row for the simple act of annoying you or trying to get you to answer, that can be considered a Fair Debt Collection Practices Act violation. They also cannot lie or misrepresent facts to you. They must tell you the correct amount that you owe. They cannot threaten action that is illegal. So if a debt collector is trying to tell you that they're going to send you to jail for not paying your credit cards, that is an illegal action that they are threatening. They also cannot lie about being an attorney or imply that they're an attorney if they are not one. They also cannot take unfair actions. This is a very broad statute that applies to debt collectors. Some of the specific examples are they cannot charge illegal interest or fees. So if you have a judgment entered against you for consumer debt right now, and they are charging you interest on it during this period in which interest is suspended, that could be considered a violation of the Fair Debt Collection Practices Act. They also cannot inaccurately report on your credit report. So they cannot report that you owe $500 when you actually only owe $100. Now talking about what you should do. During COVID-19, again, if you have a consumer debt judgment entered against you, make sure that you're not being charged interest. What I recommend is that once the order expires, that you reach out to the debt collector and get a copy of the ledger to make sure that you aren't being charged interest during a time where they legally could not charge it. I also recommend that right now, if you are having issues struggling with debt, or with debt collectors, reach out to an attorney, get advice about what your options are now. We expect creditors to race to the courthouse to get new writs of garnishment once this order expires, and you want to make sure that you have a plan in place now about how to deal with your debt. We understand that people are struggling right now, and we don't know what the next month will look like, but we can explore all of those options with you. At all times, not just during a crisis, you should always keep a communications log when you're talking with the debt collector. Write down the name, date, time of who you spoke with, what company they were with, what you talked about. We also recommend people get validation or verification of the debt. Under these laws, you have the right to request certain information from the debt collector, like who the original creditor was and the amount that you owe. We recommend that people collect as much information about the debt as they can. We also recommend that people speak with an experienced attorney about your rights under the Fair Debt Collection Practices Act and Washington's Collection Agency Act, and that you enforce your consumer rights. If a debt collector is calling you at work and you're not allowed to receive calls there, tell them about that. And we're going to go ahead and open it up to questions. If you have any questions, go ahead and enter those in the chat box on your right. So I have a question of whether debt collectors are considered an essential business. Based on my reading of the stay-at-home order, debt collectors are not considered an essential business. Right now, we know that on May 4th, there may be some changes to the stay-at-home order, but as of right now, I do not believe that they are considered an essential business and that they should be operating right now. Our next question asks whether you can be served even during social distancing laws. That's an interesting question. We have heard about some process servers shutting down during this time, believing that it's not safe to continue serving people. They may continue. We also have heard of people continuing service during this time. I recommend that if anyone is served with a lawsuit during this time, that they still contact an attorney right away. Even though most courts aren't entering motions for default judgments, we still recommend that you respond as soon as possible. Our next question asks, will outstanding debts continue to accrue interest and fees by debt collectors until May 14th? So this proclamation is very specific. It only applies to consumer debts, so debts incurred for family, personal, and household purposes that have been reduced to judgment. So if a judgment has been entered against you by a court for consumer debts, then interest and fees may not accrue during that time. We have heard about other companies like student loans not accruing interest during this time. So it all depends on the type of debt that you have. It's very specific to that. Somebody asked how can you tell if a debt collector is considered a law office, or maybe in the reverse, if a law office is considered a debt collector. So a debt collector is somebody who collects on the debts of another person. Not all lawyers are considered debt collectors, but some are. We find that there are many lawyers and law offices who the bulk of their work is collecting on debts of another. They would be considered debt collectors in that circumstance. If you have a question about whether the law office or the debt collector who is contacting you is truly a debt collector as defined by the Fair Debt Collection Practices Act, or if they're under Washington's Collection Agency Act, we recommend that you reach out to an attorney. There's some pretty detailed tests that go into whether someone is considered truly a debt collector. Our next question is whether they can record calls if you protest. So if a debt collector is trying to record you and you do not want to be recorded, I highly recommend that you tell them that right away. I believe that under Washington law, they are no longer allowed to record you. If you have concerns about that, we recommend that you hang up and that you put that in writing that you do not wish for them to record you. We also recommend that you continue to keep your communications log noting that. So that way, if you have communications with the future and that they record you, or tell you that they're recording you, you know that they're not abiding by your wishes for that. And another question asked if we have any tips for negotiating debt down. Negotiating debt is really depends on the circumstances, depends if there's any legal defenses to that debt. It also depends on the amount of the debt. What we really recommend is that people reach out to an attorney or reach out to a certified financial counselor for help if they are considering settling or negotiating debt. They should definitely see if there are any legal defenses to the debt. Sometimes I have people call who want to try and negotiate a debt, and it actually turns out it's beyond the statute of limitations, that they are no longer able to collect. So instead of trying to settle it down, we're telling the debt collector, you don't even have the right to collect on this. There's a lot of debt consolidation, debt settlement scams out there. So we recommend that if you do go with a financial counselor for that, that you do your research, that you get recommendations from people that you know, you go online and research these folks, and make sure that the company that you're going with is reputable. Again, there's a lot of scams out there, so just be careful about that. And I don't see that we have any other questions. Our next session in the Northwest Consumer Law Center webinar series is Protect Your Home Equity Scams in the Age of COVID. We're going to have Northwest Consumer Law Center board member Melissa Hulsman with us. That'll take place on Wednesday, May 6, 2020 at 6 p.m. We've been finding that in times of economic crises, that the home equity scammers are ramping up their efforts. So we want to make sure that people know the red flags of a home equity or a foreclosure rescue scam and what their options are. You can sign up for those online at northwestconsumerlawcenter.org/COVID-19. We want to hear from you. We're continuing our Northwest Consumer Law Center webinar series every Wednesday at 6 p.m. We want to know what topics you want to learn more about as this crisis continues. You can send in your thoughts in the chat box on your right. We'll be reviewing those and creating new sessions as new topics arise. You can expect that if there are any updates on garnishment, updates on student loans, foreclosure mortgages, we'll be continuing to create new content. The other sessions in our Northwest Consumer Law Center webinar series, How to Survive the Financial Effects of COVID-19, are available now on our website, nwclc.org/COVID-19. We already have sessions up on landlord-tenant law, on mortgages and foreclosures, student loans, bankruptcy, dealing with consumer debt. Those are all available on our website. This recording will be available on our website tomorrow afternoon. We recommend if you are trying to seek legal representation for a consumer matter that you reach out to the Northwest Consumer Law Center. We provide legal help for people of low and moderate incomes. You can apply for legal representation online at nwclc.org/get-help or by phone at 206-805-1722. If you have any questions after this webinar, feel free to reach out to us at admin@nwclc.org, and you can learn more on our website. Thank you for joining us tonight, and take care.